The first step, obviously, is if you don't have counsel, to retain counsel. In the state of Florida, corporations cannot represent themselves like natural persons can. Sometimes small claims will exempt that particular rule, although there's really nothing codifies that says that's the case. But sometimes procedurally, small claim judges will let representatives of a corporate entity or an LLC or some other type of business organization to be represented by one of the officers or directors or managers. But typically speaking, if you're not in small claims court, then a corporation or other business entity that is not a natural person has to have an attorney represent them, so they don't really have a choice. And then, it depends on what type of suit. Business law is at a very, very broad range. So to protect the company, it depends on what kind of suit's being brought forth, what are the counts, what are the possible defenses. So the attorney would do a preliminary analysis, hopefully prior to litigation actually being instituted. But sometimes that's not the case. Sometimes the first time you hear anything is when a lawsuit, along with a summons, hits the registered agent of the company. And then you have to react and file an answer or a motion to dismiss or some other type of responsive pleading. But then really it's the attorney's job, with the guidance of whoever the business entity is authorizing to be an agent, to deal with the attorney, whether it's the entire board of directors or a board member or an officer or a manager, that would work in concert with the attorney. And obviously there would be an analysis of cost-benefit analysis in regard to trying to settle the case versus litigating all the way to see if there's attorney fees provisions one way or the other, if there's a attorney fee provision for the prevailing party, what the likelihood of the business coming out as the prevailing party. So there's all those considerations once a suit has actually been filed against a business entity.